तेहलगांतल्या महिला कर्मचाऱ्याच्या विनयभंग केशींत तरुण तेजपालाचेर म्हापशां सत्र न्यायालयाच्या आदेशाचेर स्थगिती दिवपाक उच्च न्यायालयान मंगळारा नकार दिलो. इतले मजगतीं ह्या प्रकरणांत अभियोगी पक्षाक आपले म्हणणें मांडपाक न्यायालयान 1 नोव्हेंबर पर्यंतची मुदत दिल्ली आसा. म्हापशां सत्र न्यायालयाच्या आदेशाक स्थगिती दिवपाची मागणी तरुण तेजपालान केल्ली. मात उच्च न्यायालयान ही याचिका भायर मारली. आरडेक्स गोवा ब्युरो रिपोर्ट.
Deciding illegality of the order passed by the learned trial court, the court has issued the notice to the state, which has been accepted by the state. The state has sought the time to file the response. The matter is fixed for 1st November for the consideration, and the court has passed the order, interim order. If in the event of the framing of the charge, the recording of the evidence would be deferred.
So what about next date?
Next date of hearing is 1st November.
So there is no stay on framing of charges?
No.
So there is.
The court said if the court framed the charge, so court has not said anything. The court has simply said deferment of the recording of the evidence.
So clean sheet has been given to the MAPSA court for framing charges.
You cannot say because the MAPSA court order has been under challenge and the court has prima facie found the case in our favor. The court has issued the notice and the court has passed the interim order not to record the evidence. So you cannot say this is a clean sheet.
Delayed pending disposal of this particular petition because the court prima facie accepted our submission that the order actually shows non-application of mind as the case of clear application of jurisdiction. We have made a specific and a very vehement plea that the case against Mr. Tejpal is utterly false, and it's not simply the submission which we are making. This is the irrefutable inference which comes from an objective examination of the material which the prosecution relies upon. So hopefully the trauma which Mr. Tejpal is facing should end, and as far as this case is concerned, will not go to trial. Not only for reasons which only the state can explain, because the state is not supposed to be acting in a very partisan manner. The state is not supposed to be taking sides. The state has to present facts, and unfortunately in this particular case, the state has, far from presenting facts, withheld facts. And it is because we had to move the Supreme Court to get the relevant material which actually exonerates Mr. Tejpal. And this disinclination of the state to bring in material which is pertinent and relevant itself shows there's a motive behind it beyond vindication of law by which the state is moving.